Very good. Good morning, all. This is Scott Hempling. I'm the hearing examiner. Welcome. We're here for a conference in case number NEPR-AP-2023-0003. Welcome. Thank you all for all your hard work. We have a lot to do today, and we'll try to be as efficient as we can. I emailed an agenda last evening to all, along with the 5 appendices at about 6 o'clock in the evening. And Secretary Seda sent the official order out, which was unchanged except for correcting the title date. And so we're ready to go. Let's start with Roman numeral 1 on exhibits. Let me ask if there are any questions about Appendix A. You've all seen this before. There are 2 things, I'll come to you in a moment, Mr. Brady. There are 2 things that I wanted to point out that are slightly new. So if you look at Appendix A, can you all hear me okay? Let's see, Ms. Chambers, can you nod your head? Can you see me okay? Okay, very good. And so if you look on page 2, item Roman 2C, you will see that Kate Bailey's team has emphasized what types of exhibit numbers can be accepted and not accepted. Any questions about that, you can see her email address and that of her colleague. Then also, if you would go to page 4, Roman 3A1, I changed one of these dates. The October 22nd date is a later date than was there before. Can't recall why we had to do that, but don't be late on that, please. I think that I know that you have a lot to do to upload, but please be sure to do that on time. And that's all I have on Appendix A. Let's see, Mr. Brady, you had a question.
Yes, sorry about the delay there. This may be premature, but I was wondering how exhibits will be handled at the hearing itself in terms of putting them up on a screen or sharing them with witnesses or things of that nature.
Yes, so I think the answer is as follows, but I'm going to have to check with the team to make sure I have this right. Unless, let's see, is Kate Bailey there? Do you have an answer to that? That would be more articulate than mine. Kate, could you go on video? You're muted. Try again. No, you're still muted. Okay, we'll come back to that question. All right, she'll work that out and we'll come back to that question. And let's see, I see a hand going up from the San Juan conference room of Dona Fila, if I've pronounced that correctly.
Margarita here, Mercado for Lima. Yes, I'm in a conference.
All right, well, 1 second. Do I have Kate, try again, please? Talk to me. No, that's not working. Okay, Ms. Mercado, is that you?
Yes, I am. Good morning. I also had a question that I think Ms. Bailey would be could address in terms of when confidential exhibits are filed through the Axiom platform, the confidentiality protections that the platform itself will have in terms of.
Hold on, Ms. Mercado. We're getting an echo. This is not working out so well. Have you got two microphones going on there?
Can you hear me now?
Yes, I need everybody.
Okay, I'm going to go on mute.
1 second. I need everybody other than Ms. Mercado and Ms. Bailey to mute themselves. Let's go back to Ms. Bailey. What do you have for Mr. Brady's question?
That has not been decided yet, but we expect to have screens available in the hearing room. We hope to have screens available in the hearing room so that we can use the platform and just pull the exhibits up electronically so people don't have to bring paper copies of everything.
Now, Mr. Brady, where'd you go? Come talk to me.
Yes. Sorry, I have a slow connection here, so sorry if I'm not appearing well.
Okay,
Um,
all right. Now,
yes,
were
that is
you,
what I was wondering.
okay, hold on. We're talking about exhibits. Remember that if you're going to use an exhibit that already I have admitted, it will be on the Axion platform already, correct, Kate?
Yes, all exhibits, whether admitted or
right.
not, are on the Axion platform.
All right. And if you decide the night before that you come up with some great idea, you're going to put it up there the night before by 8 o'clock, right, Mr. Brady?
Yes, for cross, understood. And I believe we did complete uploading all of our exhibits
All
to
right.
date as
Okay.
of Sunday.
So what's going to happen is that we will get instruction out on this. Thank you for bringing this up. That tells you exactly how you're going to load it and show it to the witnesses. And no, you don't have to bring paper. Okay, Mr. Brady, is that good for now? But I've got it on my list to get an order out on that topic as soon as we've nailed down exactly the URL and the procedure. Everything okay, Mr. Brady?
Yes, thank you.
Okay, Ms. Mercado, you're next. Thank you.
Yeah, on that topic of publishing exhibits for the witnesses, I would flag that the record has Excel spreadsheets that may be very small prints or many tabs. So as you consider using the screens to show published exhibits, consider that maybe some spreadsheets may not be legible for the witness if they're far away from the screen.
All right. Well, I think the good plan then is if you think you've got a situation like that, bring paper copies. On confidentiality, we'll come to that under a separate part of the agenda, Ms. Mercado, okay?
Oh, okay. That's fine. I also had a question as what you or recently mentioned that by 8 p.m. the day before, parties can upload identifications to use in cross-examination. The order mentions that is allowed to introduce evidence. I wanted clarification on that because my understanding would have been that this would be for impeachment purposes. So if someone who has substantive evidence that should be identified before, like before we start the hearing, everyone should identify their evidence. This should be also for impeachment only. The allowance to introduce those identifications the day before.
That's exactly right. Did I ever say something that contradicts that, Ms. Mercado, or something that was not clear? Please tell me.
The order says introduce documentary evidence. So it doesn't say for impeachment purposes. So that's why I want to clarify.
Yep. Don't try to play with me with this, folks. Okay. You've got time. Get it done now. You've got rebuttal for interveners coming up, and you've got surrebuttal for the applicants, and that is that. Now, that doesn't preclude your hearing examiner or your commissioners from saying they want something new, but that's the only way that can happen. Everybody good? Anything else on Appendix A? I know a lot of you have been go ahead, Ms. Mercado.
This is an item that we had raised in an email a few weeks back, but when you have clarity, please inform us on interpreters. If witnesses are going to testify in Spanish, how the live translation to English at the hearing would be done.
Yeah, thank you for that reminder. It is actually on my list, but it's not on today's list. But thank you. But what I understand is going to happen is that the official language, boy, I hate to say it this way, but the official language for the conference is English, for the hearing is English, but we will accommodate whatever people need as those needs arise. And that is what the plan is, and that the transcript will also be in English. Now, I hadn't thought through whether we need to make a Spanish translation of the transcript. If that's a concern for somebody, and I appreciate that it can be, let me know by email, and I'll have to figure out how that's going to be handled. That's being handled by people at the Bureau rather than me, but it's on our list, and thank you for that. And we will accommodate, of course, whatever anybody needs. Okay, anything else on Appendix A?
No.
All right, very good. Now, confidential materials, Roman numeral 2. So I wrote here, just in case not everybody got to read it right away, what I hope can happen fairly quickly. Our goal at the moment is to determine the extent to which we will need confidential sessions. We're not going to determine that today, but that's where we want to be when this is all done. Now, I circulated for you the Axion folks. I don't know how they did this so fast, but they put together Appendix B, which is a list of what they understand to be all of the confidentiality assertions. So I don't expect that people have done this yet, but I need confirmation that we have a complete list. And we will add to this list if there are, unfortunately, any more to add. So what I think I would like to ask people to do, today's Thursday, would it be unreasonable for me to ask to have this by the end of the day Friday, or would you like till Monday? Anybody who says something is missing to let me know that it's missing. Would you like till Monday? We'll do Monday. Can you all live with Monday? Okay,
Yes.
anybody got a concern with Monday, say so. Okay,
No,
so go ahead, please.
I would just add that Luma is still receiving requests for information, so there may be a few items that could come after Monday.
Right. You just follow the procedure that you've been following, which is to file a motion. Kate's people will update the document. And every couple of days, if we will put out a revised document with a date on it so people know that we're up to date. But I want to get, we don't want to do any of this messing around during the hearing. So we're going to get to a point where we're done with this. So Monday, I'm asking for confirmation of the October 15th version. So if you want to mark this document, I didn't put a date on it. The Appendix B is as of October 15th. Because it does not include what I got this morning. All right, let me make a note for a moment. Okay, and then the remaining steps, if I get everybody's attention now, step 3 is to attempt consensus on narrowing confidentiality claims. Now, I'll be straight with you. I've not looked at all this material. I'm just the hearing examiner and, overseeing all the consultant reports. So I've got those duties, but I'm going to identify you for now, the ones which, just based on looking at the title, okay, I did not look at the material, that I wondered about. Okay, I'm not saying there's anything wrong with the claim. I'm just saying that when you look to see if you can work out narrowing, would you pay special attention to these? And I don't mean to exclude others. And I'm just going to go down the list. Roughly the fourth item, I'm at the far right column. FEMA detailed scope of work for AMI. Actually, the next three as well. The 205 and 206, and the prioritized list of substations. Again, I was just working off the titles. I could be dead wrong. Okay, next, about halfway down the page, inventory burden policy. About 4 down after that, response to requests to identify flaws in Luma's model of reliability benefits. As well, the next 2, comparison of Luma historical reliability and info on reliability improvements / outages. 3 down, secondment agreement. And that's it for now. Again, that's just your hearing examiner's scan without knowing anything. But what I would like to think about now is how we might go about attempting some consensus on narrowing these claims. Anybody have any ideas of how to do that? Well, the first step would be the person making the claim take another look at it and see if you really just rethink it. Why don't we just start there? And just keep it simple. Rethink them all. There's only about 25 of them. Go through them all. Make sure you're deadly certain that you comply with the requirements for keeping things secret. And if you have a way to loosen something up, loosen it up. Let's have that happen. And then simultaneously, anybody that really is bothered by one of these claims, I don't want to hear any debates during the hearing. Okay, so anybody that has a real problem with one of these claims, this is the time to make up your mind about it. So that's my thought. And if I don't hear about anything, I don't hear about anything. But if you have a real problem with one of them, you call up the entity claiming confidentiality and see what you can work out. I think that's probably the best way to do this. If it doesn't produce anything, we'll just leave it where it is, which means that everything stays confidential until April, when the Bureau makes up its mind about what to do with these things. Any thoughts or amendments or better ideas? Anybody? Okay. Always happy to hear from you. So the last point is, my thought is, if we're going to have confidential sessions, we won't go in and out in the middle of a panel. I did that at FERC. It seemed to work pretty well. It's better for the transcript, but I just don't have a good feel for how smoothly things will work. But we will do it at the end of each panel, rather than wait until the end of December to do it. Everybody okay with that plan? Any concerns? Okay. All right. Everybody's favorite topic, panels. So we're renaming my error here. Customer service should be customer experience. Customer service being a component. Revenue decoupling, it could go on rev requirements. It could go on rate design. We're going to do it on rate design. And my thought is we do it first, just so that Ms. Whited can get on and get off and go back home. By the way, I thought I noticed some of my consultant colleagues on here. The only person I need today is Ms. Bailey. I don't need anybody else billing hours for a mere procedural conference. Okay, scope of solar issues. Can I just get a quick update on that? I did get a very helpful email from Ms. Chambers the other day. Anything to add to that, Ms. Chambers?
Still working very diligently. Can you hear me?
Yes, ma'am.
Okay. We are still working very diligently. We've very much narrowed the scope. We probably had over 20 or 30 areas of disagreement, and we've significantly narrowed that. Hope to have, a resolution by Friday.
Okay.
But we will let you know if there's one or two items that we just can't agree to.
Really, I'm hoping not to have to write any more orders on
Yes,
this topic.
And
okay.
we don't want to have to be in that position either. So
Okay.
we're working on it.
Yeah, I also don't want an appealable issue. Mr. Rua, how are you today? What do you have for us?
Great. Just to second what Ms. Chambers said, we're having a very, very, very fruitful, good faith conversation on those issues.
All right. Okay. If you need me, well, don't ask. Okay, Mr. Brady. Mr. Brady. You can take your hand down
Yes,
there. Yeah. Go ahead, Mr. Brady.
I believe our deadline for objections to certain testimony is upcoming. So given that the filing on solar issues didn't come in yesterday, and it sounds like may not come in until Friday, I just wanted to confirm that we would have a commensurate extension in the time period to object, should we need to, on solar.
Yeah. Thanks for that. By the way, what's your horse in this race, Mr. Brady?
Likely none. We just want to see the outcome of this resolution and what is in and what is out before we make a determination on whether to object.
Okay. I hope what you all are doing are not rewriting my order, but just figuring out how to comply with it. But if I have to rethink the whole order, I'll do it. But understand, I'm as busy as everybody else is. Okay. Well, Mr. Brady,
just to put a little bit of a explanation on this. We went with the people that submitted testimony on solar issues, and that's who we talked to. So when people didn't submit any testimony, we didn't address them. But if there's something that they need to address, if they could just call me, I'd appreciate it.
Okay, I think Mr. Brady's just curious. He's on trying to stay on top of it all. Just a second. So let's see, worst case scenario, Ms. Chambers, worst case scenario, what do I get at the end of the day on Friday? A list of what? Portions of testimony about which there is not agreement as to in or out. Sorry, I've got an echo here, please. Everybody unmute, everybody mute, please, except Ms. Chambers for a moment. Tell me go ahead, please.
It would be a few-page list of portions of testimony, if any, that we have objection to. That's the way I'm viewing it. I could ask Sessa and so on to reply, but the way I prepared it right now is we've got a narrow set of questions and really lines of questions, I think it is more, where we might have a disagreement as to whether it stays in the case or not, and that would be all you would be receiving, because everything else would mutually agree to withdraw.
Okay, and the shortest number of words, what I'm getting on Friday is if there is a disagreement that remains, is a list of passages from testimony which somebody wants withdrawn, which somebody wants struck.
Right.
And that's what I'm getting from both sides, either side.
Yes, with the arguments, hopefully, a short passage to explain what the disagreement is.
With the arguments in a single document, okay? No fancy motions. If I need more, I'll get more, but I don't think I'll need more. Mr. Nieves, how are you today, sir? What do you have for us?
Very good. Thank you, Mr. Hampton, and hello to everybody. Just to add to Ms. Chambers' arguments or explanation of what we're doing, first of all, I must stress that all of the parties, SON, CISA, RUMA, have been working hard, and we have reached agreement on each side to withdraw testimony, and we are very close.
Okay.
However, what Ms. Chambers is saying, that what we will be producing is a limited list of the things that we cannot get to agree on. But most of the things we have gotten agreements already. We have met several times, and there have been very good conversations.
All right. So actually, I'm getting two lists. I'm getting a list of all the agreed upon exclusions. Is that correct? I'm getting a list of it.
If you want that, I was trying to limit what you had to deal with, so we could do both, whatever your preference is.
How do we execute the exclusions?
Oh, I would think that, we would file something after Friday, just memorializing everything that's coming out.
Okay, that's fine. That's fine. Okay. We'll figure. So basically what you would file is I'm just trying to think how we do this. Ultimately, there's a list of exclusions, and then people on their own would just do redline their own documents. I don't want another whole set of things being filed. Can we just have everybody do that on their own? Everybody can edit their own documents. And what's most important is that the document that Ms. Bailey is managing, that's on the web, that's going to the Court of Appeals, has the redlining on it. And you all can check that, I guess, after she's done that. Does that make sense, Ms. Chambers?
We were actually thinking about filing just clean copies, of updated copies of the testimony, but if you want it for yourself, I'm happy to produce a red line, but I thought we were thinking the official version would just be the clean copy, but it's up to you. I mean,
well, I got a better idea. Let's let Kate Bailey handle that. She's so much smarter than I am.
Okay.
And she needs to consult with our appellate attorney on this. Okay, that's what I think has to happen, Kate. Consult with Edgardo and figure out what we're going to do with the final version. But okay, Friday, I just get the disagreements. Mr. Fernandez. Okay, Mr. Fernandez, how are you?
Hi. So it was just on the same topic, whether to file, redacted transcript, red line, text blocked out. So,
we'll let you know.
Just let us know how to implement it.
Okay. 1 second, please. We'll have to go through the same drill for any testimony for which there was an objection, which is coming. I don't remember what the date is, but I think somewhere around the 20th. If I have any objections to testimony, I get those. Okay, let's continue down the list, folks. Excuse me. Okay, Mr. Gonzalez, we're not doing QFs. We're not doing avoided cost in a base rate proceeding. That's, of course, a wholesale transaction whose price is established under the FERC rules, under the Public Utility Regulatory Policies Act. It's not a base rate issue. So as far as I'm concerned, it's not in this case. Does anybody disagree with me? All right. Now I have some questions about the pension panel. Can I, let's see, Ms. Valle, or whoever is going to talk to me about this. Ms. Valle, welcome. How are you today?
Good. How are you, sir?
Okay. Well, let's find out. What is it that, let me start with you, okay? What is the issue that you think the Energy Bureau is obligated to decide with respect to pensions?
Well, sir, I'm gonna do my best to give a response today. So what the Energy Bureau is required is to set the rate amount that is required to cover PREPA's pension obligations.
Okay, so your view of the just and reasonable standard under Act 57 is that these costs are costs of providing electric service, and all reasonable costs of providing electric service have to be in the rates, and the pension obligation is a reasonable cost, therefore it must go into rates. Is that the line of reasoning?
Well, yes, I would add that it's an unavoidable cost. It's a contractual and statutory obligation of PREPA.
Yes, it's a legal obligation, and I assume your view is that it was entered into prudently, and therefore under the just and reasonable standard, it's like any other cost and has to be in the rates. Am I understanding you correctly?
It's not like any other cost. I would say that because it's an obligation that was already entered, it's different from obligations that PREPA will be entering into or other operators will be entering into in the future. So, and the obligations that PREPA or the operators are entering now and into the future, the Energy Bureau has a discretion, whereas in obligations that were entered into in the past, it doesn't.
Okay, and the 370 million, if I remember the number, reflects.
I will apologize. It's 307. I wanted to clarify that. 307.
You should never apologize for correcting my mistakes. That's your obligation, okay? I will apologize for making them. 307. Now, that all relates, yeah, great. You put it right there in a document that 80 people saw. Thank you. Now, that 307 represents obligations already incurred. Is that correct?
Exactly.
Okay.
That's correct.
All right. And I imagine you would say that those who say the customer shouldn't pay for it because this amount is a result of fouling up by the prior pension administrators, you would say that that argument is a complete irrelevancy because the obligation is the obligation, period. Is that your position?
I wouldn't say that it's of complete irrelevancy in terms that going forward, it's relevant, but not towards the PREPA's request to cover the pension obligations.
And you're not asking for any of the going forward money in this rate case?
To the best of, yeah, based on the information that I have thus far, no.
Okay. Well, that's what I wanted to understand at the moment. Does anybody want to say anything? This is not the last time you get to argue about this, but does anybody want to say anything? Mr. Emanuele, how are you, sir?
Yes, very good, sir. I'm representing the retirement system. I would like to add that also the cost that Mr. Valle mentioned includes the administrative cost of the operation of the retirement system. Yeah. Because to pay the pensions, you need money to pay the employees and to pay the operations of the retirement system.
Yes. And that's PREPA's obligation to pay those costs.
Yes.
So that's part of the deal. Go ahead.
That's part of the deal. That's part of the regulations of PREPA also.
Okay.
Yes, but to your concern, and yes, I agree with what Mr. Emanuele just said. But to your concern, it's not. We're not requesting any money for backing up the pension.
I beg your pardon, for what?
It says here for backing up the pension. It goes, the money that we're requesting goes to making current payments for retirees and the administrative expenses that are required to make those payments.
Yes, I fully understand you and thank you. I'm not meaning to introduce any controversy over the issue. I want to make sure I understand exactly what we are doing about this. Okay. All right, Mr. Emanuele, was there something else you were about to say, sir?
No, that's all. I agree with Ms. Valle's position.
Okay. Why, Ms. Valle, did you put CEO Zapata on the panel, but it's CFO Ocasio who testifies about the subject? If
Well,
my memory is correct. Go ahead.
So initially, the way we were envisioning it was to have additional. It was going to include someone from the finance department, which originally had been the CFO, but now that he's not longer with PREPA, it will be PREPA's controller. But the latest roster that was submitted, our proposed panelists were based on your request that we reduce the amount, and PREPA's panelists, the panelists that PREPA proposed for the pensions panel, it's not only my decision. So I also have to discuss it with Ms. Zapata, and Ms. Zapata decided that if it was going to be a reduced panel, she wanted to be the one that appears and justifies such an important request.
Well, we want Mr. Ocasio there, okay?
Well, it's going to be Adrover because he will be substituted.
Okay, so he is going to be substituting for Mr. Ocasio's testimony.
Correct.
Okay.
Exactly, yes.
Well, if Ms. Zapata wants to come also, that's fine with me. I assume
Okay.
nobody objects, but I want Mr. Adrover there because he adopted that testimony. Now, I'll tell you, that could be an awfully short panel. What is it that you think Ms. Rivera or Mr. Porter would be adding? Because I'm not aware of any dispute about the 307 million. So I'm beginning to wonder whether this panel is going to last any more than 10 minutes. What did you need Ms. Rivera and Mr. Porter there for, Ms. Valle?
We just wanted to be thorough. Porter is our financial advisor. He's understand well the documents and the analysis, the underlying analysis. And Ms. Rivera, she's the current administrator of the PREPA ERS. And if the panel had any question that they wanted to ask about the administrative costs or something along those lines, or the projections that are submitted to the finance department, that sort of thing.
Is anybody disputing the 307 million in this case? I mean, I'm not aware of any. Let's see. I'm not aware of any testimony that disputes the 307. Are you, Ms. Valle?
No, sir.
Okay, well, I sure don't want to use panel time and the time of important executives if we don't need it. I'm not saying we don't. I'll have to check with my team. But you've answered my questions, and that's why I asked them today, so I can make an assessment of how many hours to devote to that topic. Does anybody have any other comments about pensions? Well, I know there's a rate design issue, but we'll discuss that under rate design. Ms. Mercado.
Sorry, the unmute button is far from me. I just had a procedural question. Yesterday was the deadline to substitute testimonies. I'm not sure if the pension testimony for PREPA will be substituted for the record, if there's any.
I've got a section that I added to the agenda in writing on substitution, so let's hold on for that, okay? Thank you. Any other comments on pensions? Okay, well, let's talk about debt for a second. Again, what I'm aiming to do here is to get a better feel for how to allocate the time across the hours. So putting aside the preemption argument that I was delighted to hear about last time we met, delighted because I always like a good legal exchange.
And Mr. Hempling, before you proceed, I will. This section will be addressed by Ms. DeConza, so I just wanted to let her know.
Well, just tell her I don't want to talk about preemption. I want to talk about Puerto Rico statute.
Okay.
She can write about preemption when the time for briefing occurs. Ms. DeConza, how are you? Okay, well, you got to unmute yourself.
Good morning or good afternoon.
Okay. Well, I'm very interested in in your views at the moment. I know I didn't ask you to stay up all night to study this, but it's a similar set of questions to what I asked Ms. Valle about pension. Putting aside preemption, what is your understanding of the Energy Bureau's Act 57 obligation in terms of rate making with respect to the debt that PREPA will have at some point as a matter of obligation. Do you have any thoughts for now? And I don't want you to guess or make it up. If you don't, you don't. We'll address it some other day. Go ahead.
I think that, Mr. Hempling, unfortunately, you can't put the preemption aside because it does impact the obligations under Act 57.
Well, Ms. DeCanza, I just told you to put it aside and tell me. I'll do the talking, sure, and I'll let you know when your turn comes. Okay. Yes, a good lawyer can interpret a state statute under the hypothetical that there's no preemption. If you don't want to do that today and don't want to help me, you can just say that, but I don't want to argue about it. Go ahead.
So I am not a Puerto Rico lawyer, so I'm not going to interpret Act 57. I would just say that Act 57 refers to obligations. The obligations are subject to the fiscal plan, the budget, and the Title III case.
Well, I guess the line of argument you could make. By the way, personally, I'm indifferent for how this thing comes out. I just want to make sure I use the panel's time wisely and that I advise my client in the best possible way. I guess you could say that if we interpret the word obligation to mean current obligation, there is none, and therefore the Energy Bureau has no statutory authority or discretion. And once again, we don't have to get into preemption, do we, if it comes out that way? Do you see why I separated the issues? Yes, you see why I separated the issues.
I understand what you're saying.
Okay. But you don't want to make that argument because you are not a Puerto Rico lawyer.
No, I'm merely saying that putting aside preemption versus incorporation of the fact of the Title III, I agree with what you said.
Okay, on the other hand, if one interprets the word obligation to mean an obligation to enable PREPA to send a signal to the investment community that it is capable of charging rates that are sufficient to pay off debts that will become obligatory soon, that would produce a different outcome. But I'm not asking you to agree with that. I'm just actually struggling. I'm letting people know I'm struggling with trying to figure out, A, the preemption issue. We've already had that discussion, but B, whether there's actually a statutory obligation to begin with. It's not clear to me that there is or there is not, Ms. DeCanza, and that's something for you to think about, all right? But before I go to Mr. Brady, I have this question for one of the two of you. What's the institutional reason for why PREPA is taking the position that the rates should not reflect anything with respect to the debt? Can you enlighten me on that? Ms. DeCanza, maybe?
Sure. It's because PREPA is subject to PROMESA and it needs to operate within the financial dictates of the fiscal plan. And it believes that the debt issues should be resolved in the Title III case, which has been ongoing for 8 years. I know some would say that is too long and it should be resolved. It needs to be resolved, but in the Title III case.
See, Ms. DeCanza, the thing about what you just said, and my style is to challenge. It doesn't mean that I have a particular point of view yet, and it wouldn't matter if I did. But here's what keeps going through my mind. And this gets back to our preemption discussion so that you can think about it for your brief. In fact, let me ask you, I forgot to ask you last time, the preemption that you're referring to under PROMESA, is it field preemption or is it conflict preemption?
It's the preemption that arises from Title I, Title II, and Title III of PROMESA. So there are various aspects. Right now, what we're talking about is what is provided for in the fiscal plan and budget, which debt service is not, coupled with the Title III automatic stay and the fact that the debt issues are being resolved in the Title III case. I think that your own experts in the Smith and Dady report, they do address all of these issues. And that the most prudent action is for the Energy Bureau to wait for the Title III court to resolve the issues and then address the legacy debt at that point in time.
Could you pay me the courtesy of answering the question I asked? Is your assertion conflict preemption or field preemption?
I think it depends on the specific item that we're looking at.
All right, well, let's talk about the specific item that I'm looking at. Setting a rate that reflects some number other than the clearly wrong number, which is 0. Is that preempted because of conflict preemption, or is it preempted because of field preemption? Do you know?
I think that we would be happy to provide you additional briefing on these issues.
Right. Well, I would sure be happy to, the next time you talk to me about preemption, you're able to answer a fundamental question about which prong of preemption we're talking about. Mr. Brady.
Yes, just to begin with, I wanted to say that we will address the preemption argument and other legal issues related to debt in post-hearing briefing. But I did want to respond to a couple of the things that I heard. First of all, I think you're exactly right to address pensions and debt in sequence like this, because I was struck that many of Ms. Valle's rationales for why pensions should be collected now apply equally to debt. Both items are currently subject to uncertainty as to amount due to the ongoing Title III case, and yet PREPA is advocating for inclusion of pensions and exclusion of debt, which is inherently inconsistent. In terms of your question about statutory obligations, I would point you to Section 6.25 of Act 57, 2014, as amended by Act 17, 2019, which speaks in mandatory language about PREB's obligation to approve a rate that considers debt service and guarantees that PREPA meets its obligation to bondholders, similar to the statutory and contractual obligation that Ms. Valle referenced as to pensions.
Yeah, but there's no legal there's no legal obligation to pay any debt, Mr. Brady. 0. There's no legal obligation today, correct?
Well, thank you for bringing that up. That was the other thing I wanted to respond to. This was there's no current obligation argument that you raised. There is, in fact, a current obligation. The amount of that obligation is uncertain as a result of the Title III case. But what we do know today is the total amount of the debt. And at this point in time, the Title III court has not adjusted the debt. There is no confirmed plan of adjustment that reduces the debt or eliminates the obligation in any way. And in fact, there's not even a plan of adjustment actively under consideration by the Title III court at this time. So while our position is that a rider should be included for debt, which is then set after the Title III, as Dr. Tierney lays out, to the extent PREB does determine to include an amount for debt, the only amount that is known right now is the total amount of the debt. Anything less than that would just be sheer speculation.
So your position actually is that the number that should go into the rider at this time is 0.
It is that a rider should be created to facilitate the implementation of the ultimate revenue collection after the Title III is complete. I wouldn't say 0, just because I don't think you would put it necessarily as 0 on that item. I think the point that Dr. Tierney makes is that if that rider is included now, as opposed to some future rate case or adjudicative proceeding, it will save everyone a lot of time and effort and ensure that the plan is implemented more quickly, which I think is in everyone's interest, including PREPA's and all other stakeholders.
I read all that, Mr. Brady, but if I thought that was enough to end the conversation, we wouldn't be taking 10 minutes to talk about it right now. Why aren't you proposing a number to put into the rider now?
Yes, so as I mentioned, I think to the extent that PREB determines that a number needs to be included at this stage, that it would be the known total amount of the debt as opposed to some speculative reduced amount of debt, which, as I said, hasn't occurred yet.
I know that you said that already. I'm asking why aren't you proposing that? That's not what your testimony says. Your testimony just kicks the can down the road in terms of the number and says do a rider. That's easy. Why aren't you proposing a number? Or are you going to do that in your brief instead of in testimony?
So I think to answer your question, I sorry to repeat myself here, but I think our position would be if a number is to be included, it would be the total amount. So that would be the proposal. All
right. Here we go again. But you're not insisting that the Bureau has a legal obligation to put a number in other than 0 at this point, or say nothing. You don't think the Bureau has a statutory obligation under state law, under Puerto Rico law, to put some number in there now? That's your position, or you haven't thought about it?
No, as I mentioned, we'll address these legal issues more fulsomely in the post-hearing briefing. I'm not sure that testimony from Dr. Tierney would be the right place to opine on the meaning of Act 57, but our position is that PREB does have a statutory obligation to address debt in the rate case, and the way that Dr. Tierney proposes to address it is to include a rider so that it is considered in the rate, but not to put an amount, and if an amount is included, that it would be the known total amount of the debt.
Well, if I ask her how come she hasn't proposed a number, I hope she's going to have an answer. Because right now what I have as evidence is nobody wants a number in there. So I'm wondering why I'm taking all this time to get into a fight with Ms. DeCanza, who's doing a great job today for her client, because I'm trying to figure out whether there should be a number. Mr. Jimenez, did you have something to add? And I apologize, I cannot remember whom you represent, sir.
No need to apologize. So I'm partner with Paul Hastings, who represent the official committee of unsecured creditors, who's an intervener in this proceeding, Mr. Hempling. I think your last comments really covered what I had raised my hand to say, which is I think the key point here is that any amounts are TBD at best at this point. They're to be determined, and therefore I don't want to get into, and to the extent you want us to, Mr. Hempling, we're happy to cover it in post-hearing briefing. But so I don't want to get into the whole preemption issue. It's more of a question of efficiency here, and who is in the best position to evaluate issues regarding what's the amount of the debt. We think, and obviously we'll say this in our briefing, that the best court, consistent with what the PREP zone consultant said, the best court to do that is the Title III court. And it has all of the pieces there to be able to do this. It's had these issues in front of it for some time. So we think that the appropriate approach here would be to let the Title III court handle its province, which is to decide what amounts, if any, of legacy debt PREPA has. And once those numbers have been determined by the court, then the PREP can decide what to do with that.
Okay. I think I've done all I can do on this topic today. Anybody else? Okay. Now I have, thank you for your patience, everybody. Panel schedule. So Appendix C1, not your last chance to comment on this, but this was my effort to guess at how things might go, because having a guess is better than not having a guess. You'll notice that the high hours estimate exceeds by now 14 hours, the 6 hours a day times 24 days, which means we may be looking at some Saturdays here and there, or we may be trying to be very efficient. But anyway, I need to do the best we can about having a schedule, because people need to make travel arrangements. And again, the far right column is a date range. Ms. Chambers, you have any comments about this schedule? You're muted.
I had a question earlier. You said that the decoupling was going to come at the beginning, but it's under rate design. But you also said it was under rate design. So I just so I understand when to have the witnesses for that. Are we talking about having it at the beginning of the rate design panel?
That's what I meant. I'm sorry for not being clear.
That's okay.
Yeah, what I meant was it goes with rate design. And I thought maybe we would do it at the beginning, because Ms. Whited does not have to be around for all of the Sam Shannon and Zachary Ming decisions. It's something that probably can be handled. A good conversation about different forms of decoupling probably can be handled in an hour or two and get that done, and she can go back home. That was the thought that I had. Can you work with that?
Yes, I was just like, I wasn't sure if it was going to come before the T&D panel. That's what I got confused about. Thank you.
My fault. And, my fault. And the only question there is where in that week of 15 to 19 it would occur, because my guess is that we are not going to need 5 days for the entirety of the rate design. Zach tells me he thinks we might pull it off in 3 days. But I'm not sure yet. But I suppose if you have a distinct witness for decoupling, some of these things we can kind of schedule with precision, like a doctor's appointment, and then work around them. But I'm not sure yet. So do you have a witness who is specific to decoupling, Ms. Chambers? Or would it still be Sam?
I don't know yet, but
All right.
I expect that we will have some of the witnesses that are already appearing will talk to this. But I don't have a final determination at this point.
I hope everybody understands the reality here. I'm going to do the best I can to create a situation where when we get to an issue, the people who need to be there are there. And also that if they are going to come early, which they will, that they don't have to come any earlier than necessary. Because I've been in that. I'm going to do the best I can. I can't promise, but that's the reason for the ranges here. And we'll know more as we go. And, you know, maybe some people will change a flight and have to pay a couple $100, but it might be less expensive than coming down way too early. So we'll just do the best we can. Ms. Vasquez, how are you? Welcome. What do you have?
Hi, Mr. Hambling. It's just a comment on the calendar. The November 19th is marked as a holiday in the agenda, and it's included in the date range. I just wanted to make certain that any changes that need to be made.
Thank you.
Are made.
So just thank you very much. Very alert. So just change that 19 to a 20. But I do expect we will do T&D first. And the reason, as we'll get to, is we're late on the generation report. And so I want to give people who have to respond, Ms. Vasquez, especially your team, the extra time. So we'll discuss that shortly. Thank you for that, Ms. Vasquez. Very alert. Okay, I have a couple of things written in here that I didn't put on the agenda. So let me discuss with them, still in the category of panels. Mr. Poe or Mr. Argadayit, can I see you here, please? If you talk, I think you'll show up on my screen. Mr. Argadayit, how are you?
Fine, thank you, sir.
Okay, so you emailed, I guess, you submitted a motion yesterday, and I had with Mr. Poe a CC to everybody, a short conversation about that. And this morning I was able to give your motion a closer read. And these are the comments I want to make on it, okay? Number one, on the question of participation in the hearing by PREPA, I made the decisions in my orders of July 18th and July 21st. And as far as I'm concerned, those decisions remain, which is, though I'm not going to allow cross-examination by PREPA of Luma or Hinera, I'm not otherwise going to gag them. And so when their counsel can be helpful to the commissioners, they will be helpful. And if people don't think that's a situation consistent with the contracts, they can take it up with the P3A. But that's the way we're going to go. That is a partial response to the motion. To the extent anybody argued otherwise, to me, they lost. But my other thought was this. In the panel on cooperation, I would like to involve not just those that are listed in Appendix C-2, but the lawyers. Because I think that the document that your client, that you and Mr. Poe filed, raises some important legal questions. If what you're suggesting is that the status quo level of cooperation is somehow less than it could be because of different understandings of the principal-agent relationship, if that's what you're saying, that's relevant to the panel. And so I want to just keep that topic open and involve the lawyers in that. People have a chance to brief it afterwards, and I promise you, I've given this only a half hour thought this morning. But right now, right now, what I want to say, I was sufficiently stimulated by that document that I thought that I should at least say that will involve the lawyers. Back to you, Mr. Agradait.
What we wanted to say, and it's exactly what you have interpreted.
All right.
So we are happy with that solution.
Okay, so I'm not going to issue any orders on this, okay? So your motion just might be hanging around in the air, but don't be too upset by that, okay?
No problem.
Okay, sir. Let me look at my notes for a second. Okay, that takes care of the that particular motion. I want to confess that with respect to the overhead, the panel that's called overhead and miscellaneous, I'm struggling with how to list all the topics that are going in there. And I expect that what I will do sometime next week is circulate my definition of the panels in terms of the subjects they will cover, and that will be tentative because I like to think out loud and you folks always improve things. But what I do need to try to create is some coherence and some clarity of boundaries among the panels so that I don't get objections about, well, so-and-so's not here, and I thought that was going to be going on panel X, and now Hempling, you're bringing it up on panel Y. I can understand that, and I don't want to have too many of those problems. It's not going to be perfect, but I'm going to try. And I think what I will do is I will ask you, I know you're at your limits in terms of work, but I'm going to ask you to try to make what I come up with better and clearer and more detailed. The more detailed, the better. Okay. Is there anything else on panels that anybody wants to say? Oh, well, I'm sorry. Go ahead. One second. What I was about to say, Ms. Valle, is that at this point, Appendix C2 Appendix C2, as I circulated it last night and this morning, is what we're going to go with. At this point, I don't know that we're going to get it any better, but let me get everybody's comments about it because I do want you to have notice. Ms. Valle.
Well, my only clarification is that in across the board, you identified Juan Carlos Adrover, which is PREPA's controller, which is going to be the substituting witness. But in one panel, I'm trying to see which one is pensions. You identified the former CFO, and I just wanted to clarify that that spot would be occupied also by
Adrover.
Juan Carlos Adrover.
Yeah, we talked about that earlier today, and I've already made a note in my document that to replace on pensions, Mr. Ocasio with Mr. Adrover, correct?
Okay.
Yeah,
Yes.
I've got that. I've got that. Ms. Mercado, yes.
Yes, on your October 14th order regarding panels, there was an item on the federal funding panel in terms of PREPA's proposed witness, Ms. Diaz. And the schedule today was to include arguments by PREPA on why that person should be included in whether that person has relevant information for the panel. I was wondering if I don't see that in the agenda, but it's on a pending item.
No, thank you for that reminder. It looks like you know my issuances better than I do. Right. Is that right? I asked the question, what's Ms. Diaz going to contribute here? Is that what I asked, Ms. Mercado? Okay, thank you for that. Very alert. Ms. Valle, what's she going to contribute?
Ms. Diaz is PREPA's federal funding advisor. She has been with PREPA addressing these issues for many, many years, even ever since Maria. So she is an expert in federal funding, and she can explain what federal funds are available in terms of federal refunds, in terms of working capital advances and other advances, what amounts have been, how many funds have been obtained in federal refunds by PREPA, by LUMA, and any other and Genera. what federal fundings are still pending, that sort of thing. I mean, she can really interpret the documents and give you an analysis on what's the status of the federal fundings, and can also contribute and help the panel and really the Energy Bureau identifies ways for the operators to improve their performance, and that will certainly impact rates, will reduce them.
Okay, so thank you, Ms. Valle. There's things that I just heard you say that I liked, and other things that I'm not sure I liked, so let me explain. This is my sense of what this panel is about and what it is not about. I assume that by now you've read, people have read the PREP consultant's submission, Mr. Guimel Cortez. And this is a rate case. This is not a management audit case. So what we're aiming to do is figure out what money should come from customers through base rates to fund electric service. And there is, with respect to the relationship between base rates and federal money, timing uncertainty and actual arrival uncertainty. Will we ever get the money? And yeah, we're going to get the money, but we don't know when. But when we do get it, we're going to have WCA issues, etc. And what Mr. Cortez tries to do is come up with a way to put into base rates some amount that reflects an educated estimate of the chances that money is going to show up in a certain amount at a certain time. That, as far as I'm concerned, is the reason for the panel, is to help us fill out that formula that he's come up with. Of course, people may want to adjust the formula. We can debate that. What I think is not in the case is this company or that company or some other company doing a good job? Now, let me be very clear. If somebody has an idea that changing activity X in the FEMA process will change the numbers that we should put into base rates, they can make that argument. And that's where your reference to improvement has relevance to the case. But what I do not think we're going to do is have a management audit of everybody's performance. That has to take place in some other case. And I'd like to know if people see this issue differently, because it has a lot to do with how long that panel goes on for and the type of people that are there. Now, based on your description, to finally get to the point, it seems to me that Ms. Diaz can make a contribution if she's an expert on the FEMA process, as is Mr. Cortez. But I don't want her coming in here and telling me 10 different reasons why LUMA has fouled up for the last 10 years, because I can't do anything about that in this case. What I can do in this case is help the Bureau to come up with the right number to go into base rates. We clear, Ms. Valle, and do you have any comments?
I'm clear, and for now, I don't have any further comments.
All right, Ms. Mercado. Because you were concerned about bringing in a non-witness, and I appreciate that, and I've tried to give some clarity as to what she would be doing here. Ms. Mercado.
I appreciate the clarity and agree with your comments and how you have formulated the purpose of the panel. I would add that given that formulation of the panel, if Ms. Diaz was going to appear as a witness, she should have pre-filed testimony in rebuttal by September 8th. Or file testimony before the hearing, so that all the parties know the position that she would take on these issues, including Mr. Cortez's testimony or expert report, and that we all have the opportunity to file a motion to strike that are due Monday. So I think it's very important that any PREPA witness on this particular panel that is technical and many information evidence is already on the record, it should be met by PREPA with a pre-file testimony or expert report in whatever form you allow.
Okay. Well, nobody's late yet. Here's how I look at that, Ms. Mercado. Thank you. Ms. Valle, I think you'll save us a lot of trouble if on the day that Sir rebuttal is due, Ms. Diaz files some kind of commentary about Mr. Cortez's testimony. And I think if she does that and does it in a way that prevents opposition because she went outside my description today of the purpose of the panel and her contribution, I think you will save us a lot of trouble. Okay? Again, Ms. Mercado, I can ask any question I want of anybody that shows up there and elicit any information I want. And then you get to say, wait a minute, I need a chance to respond to that. And I'll listen to you when that time comes. Okay? So with that, go ahead, Ms. Mercado. Yes?
I agree with that. I agree with you. I just want, the same rules to apply to all the parties regarding pre-trial testimonies and what they can offer offensively in the process before they get to question.
I hear you. I have to tell you, every single day I come to work, I'm thinking Court of Appeals. Okay, because what I want, I'm deadly serious. What I want is if you want to go to the Court of Appeals and complain about the Energy Bureau's judgments and how they weigh different factors, good luck, because you'll lose in the Court of Appeals. They'll defer to us. But I don't want you going to the Court of Appeals complaining about fairness and procedure. And that's my job, is to make sure that you are all happy. So you get up and you tell me when I've fouled something up, and we'll deal with it. And the same thing goes for Ms. Freyer, Mr. Jimenez, with debt. At this point, I'm really not sure what she's going to contribute there, because frankly, I'm not so sure what we're going to accomplish with that panel, given how I understand now that nobody wants a single dollar from rates going into that rider, if there is a rider. So I need to think about that debt issue. Okay, let's see. My last comment on, I'm sorry, Mr. Agrait, go ahead, sir.
Yes, I'm going to ask you to permit me to go one step back concerning the panels,
sir,
and ask a question. You put with a question mark excess participation in both conflicts and inter-utility cooperation, and then you said that you wanted the lawyers there. I intend to appear on both panels as ICSE, not only as ICSE lawyer. Is there any problem with that, or will I have to bring an independent witness?
You're referring to both the conflicts panel and the cooperation panel?
Yes.
All right. Well, here's my answer, and I thought about this ahead of time. As far as I'm concerned, Mr. Agrait, you and Mr. Poe and your organization bring something unique. And I don't care whether you're talking as a lawyer or talking as a citizen or talking as a knowledgeable person that's been around longer than I have. You make a contribution, and so you appear.
Thank you.
And if anybody has a problem with that, let me know. Okay. So I need to remember to put your name down here. One more comment on the panel. No, two more comments. Ms. Mercado. Oh, that may not be an issue. 1 second, please. Okay, okay. Yes, concerning the budget panel, Ms. Mercado, I'm sorry, did you have a question first, ma'am?
Yeah, I had a question, but I can wait after yours.
Okay. Mr. Balbis and Dr. Terzic.
Yes.
I hope that between now and the time we have the budget panel, those two gentlemen have given very careful thought to the difference between the Puerto Rico context and the typical investor-owned utility context in terms of how to discipline spending. Because in the traditional IOU context, the way a regulator can discipline spending is to forbid the recovery of the costs. And that, as everybody knows by now, I hope including those two witnesses, Puerto Rico is very, very different. And so the insight of the 2017 order was the only way to discipline spending before it occurs is to budget ahead of time. And I can't tell you that I've memorized every line in both those two gentlemen's testimony, but I sometimes got the impression that they thought they were in a very different kind of jurisdiction. Now, if I'm being unfair, that's fine. They'll have time to, you know how I operate. They'll have time to set me straight when they come. But I can tell you right now that if they're going to come to the witness stand and be talking about how Puerto Rico is just like an IOU context, it's not going to be a lot of fun for me or for them. And that was my concern when I glanced at their testimony. There must be a way for this Bureau to discipline spending because there's no way to get it back once it's been spent. That's all I have on panels. Okay, let's talk about, I'm sorry, Yes, ma'am, please.
Yeah, I had a comment on the order or the allowance that ICSE through council appeared 2 panels. I have concerns with those, with that, and we could articulate them further separately, but initially, I would ask that they pre-file testimony or at least provide a detailed proffer of the topics that they would discuss in each panel, and when they would be speaking, Mr. Agraid would be offering testimony as a fact witness, and when he would be acting as counsel. You know, there are considerations of conflicts, whether an attorney for a party can do both. I'm not imputing anything right now. I'm just saying these are concerns. So I think the guardrails should be very clear if this participation is going to be allowed. That's my recommendation right now. I have concerns to discuss with my clients separately, but initially I will be my request that we all be advised of a type of testimony versus advocacy or opinions as a legal counsel.
Okay, again, thank you very much for that. Exactly what we want here. So I have 2 immediate thoughts. First is I'd like you and Mr. Agarayit to try to work something out so that I don't have to deal with it. I think that Mr. Agarayit is a very learned man and he understands exactly what you're talking about and doesn't want to create any vulnerability in the record that we don't have to deal with. And your concerns are also completely fair. So number 1, I'm going to ask Mr. Agarayit as a condition of my putting him on this panel to make an attempt to work something out. I don't know what you're going to work out. Number 2, I don't expect that he's going to bring any facts in. Sitting here right now, I can't imagine what kind of facts he's going to bring in. And I'll tell you what, the time for bringing facts in is gone. All right, it's gone. No, we're not creating. I put this in the order the other day. There's no more written testimony. That's why we have a procedural order around here. So he's not going to bring in more facts. I wanted to include him because of his policy thinking. And I view, well, yes, there's obviously factual bases for concern about both the cooperation issue and the conflicts issue, but I'm much more interested in solutions. I want to try to help us all educate each other and the commissioners about these difficult questions. So I can tell you right now, Mr. Agarayit, don't plan on bringing on any facts that aren't already in the record. You work with the facts that we have, which I think Ms. Mercado obviates written testimony, but I'll leave it to you two to work something out. Why don't you come back to me a week from now with something? Okay, so that would be, what's today, Thursday, a week from tomorrow, which would be the, can I do the math, 24th. No facts, no, thoughtfulness, Mr. Agarayit, thoughtfulness, not facts. Go ahead, sir.
I agree completely with attorney for Luma issue, and I think it's very reasonable. And of course, I'm not gonna testify concerning issues that are not already on the record or determination that already have been taken by the Bureau or by you in the process. And I will work with Ms. Mercado to clarify this and put the guardrails in place. And I plan to submit a pre-hearing document that basically states what I will be saying in terms of policy and remedies.
Well, just 1 second there, Mr. Agudait. I don't have a place in the procedural schedule for that. And I'm the first person to say the more I learn, the better I am. But I'm going to say to you, don't do that. Okay. Now, if you want to talk, listen, put Ms. Mercado in a position where I don't have any trouble. Okay. If you want to tell her what you're going to talk about, just so you can rehearse it and you'll get a better conversation on the record, you go ahead and do that. But don't file anything else. Okay. All right. Thank you. Ms. Mercado, anything else on this topic for now?
No, I will meet and confirm with Mr. Agudait, and then we can.
All right.
It's back to you.
No, I know you have a very large workload, and I appreciate that effort. Ms. Vasquez, I'm listening.
Yes, just want to state that Henry also wants to be a part of those conversations, so we can coordinate with Luma and Mr. Agudait.
Work it out. Try to keep me out of it, okay?
Okay, thank you.
Okay. All right. Let's go to item 4. Do you all want to take a 5-minute break? Let's do that. I've got 12:47 here. I'd like us to come back at 12:52. Would you all mind? Back in 5 minutes. I'm going to go dark. Thank you.
That was quick. Did you guys walk?
Yeah.
No, I got a yogurt drink.
Okay, I'm back. Okay, Gerardo, we can go back on now. Kate, I think actually I should have said this earlier. You can go. I mean, I don't need you for the rest of the meeting. I should have been more awake about that. Okay. Okay, colleagues, we're going to start back up in about 1 minute with part 4 of the agenda. I can get Ms. Vasquez up here so we can discuss this. Let's see. We'll wait about another 30 seconds. Ms. Valle, did you have something before we go to part 4?
Yes, I had a question, and it's everything the statement regarding cross-examination. And I just want to confirm, because you stated that PREPA, your determination was focused on PREPA not being able or authorized to cross-examine at the hearing, and I just want to confirm that that applies to all applicants, that Luma will not cross-examine PREPA, that Genera will not cross-examine PREPA, and that applies to all.
Very good question. And your reasoning would be?
Because it's the first, we all, as I mentioned, we all had a statutory right to cross-examination under the Act and under the applicable framework. And if PREPA is being interpreted as having waived that, which I have my reservations on that interpretation, but that's how it's being interpreted in the case. So if PREPA implicitly waived its right, everybody that entered into the agreement waived it as well.
Yes, thank you, Ms. Valle. So I understand your reasoning. First of all, let me make a friendly amendment to the way you explained that. I think the way I put it in my order,
yes,
whether it was October 18th or October 21st, I didn't use the word waiver. I think I said you contracted it away. That you had that. I didn't disagree with you that you have that right, but my argument, my reasoning, judges don't argue, they reason. My reasoning was that you can contractually give that away, and you did. And yes, sitting here right now, tentatively, I can't see why that reasoning wouldn't apply in both directions. But I need to make a note to myself and make sure that I am agreeing with myself. So you've caught my attention on it just as you intended to. And give me a second to make a note. Again, very alert, Ms. Valle. Again, as I made, yes, I will confirm this or not confirm it. I will do something about it so that you can be clear on this. I really don't want to have a lot of argument about this during the hearing. The way I left the order, I think the October 21st, sorry, I got the dates wrong. July orders. Essentially, I don't want to gag people when they have contributions to make. The decisions that the commissioners have to make are too important. My order viewed the cross-examination process as inherently and exclusively adversarial. And I viewed the combination of the statute, I think it was the 2019 statute, and the OMAs, the contracts, as creating a non-adversarial relationship, and cross-examination being inherently adversarial meant that was off the table. Now, you can accuse me of inconsistency, and I think I might have even alluded to that in the second order, but I want to learn, and I want the commissioners to learn from people that have something to contribute. So take a shot, not through cross-examination, at standing up and saying, hearing examiner, you need to look into such and such. And we'll deal with it when it comes. I'm not going to deny the commissioners an opportunity to learn. So we'll do the best we can, but we are going to try to honor the statute and the OMA and their expectation that the relationship will be cooperative, not adversarial. That's the best I can do for now, Ms. Valle, okay?
Then I would like to request a written ruling on the matter. And I understand that because cross-examination is one thing, allowing the panels to pose a question for the Energy Bureau to then determine if it's going to be addressed by the panelists. I think it's a different dynamic. So I just want to make sure that if PREPA is not going to be allowed to cross-examine, not the other applicants are going to be allowed to cross-examine. I just want to make sure that the ruling applies to everyone equally.
All right,
in terms of the applicants.
You've made your point. I've heard it loud and clear. I've made a note on page 1 of my notes. Okay?
Thank you.
Okay, thank you. Let's go to part 4 of the agenda. Everybody, thank you for your patience and your help today. Now, Ms. Vasquez, let's start with you. So I said what I had to say here. I'm suggesting later deadline for interveners and for applicants concerning generation. Everything else stays the same. Can you live with this, Ms. Vasquez?
Yes, we can live with this.
Basically, I'm squeezing my own people, but we caused the problem. We're going to have to deal with the problem. Okay, so we're good.
Yes.
Anybody have? Sorry, Ms. Vasquez, go ahead. Something?
No, that I saw also that the generation panel is the week of the 17th, so it works for us.
Yes. All right, then we're good. Any concerns there? No concerns.
No.
Okay, thank you. Hearing logistics. So let's see, what can I say about this? I sent you a tentative way. It's really not up to me how this is going to get set up, but what I want you to understand about Appendix D, the diagram, is that table that says cross-examiner. So when I or my colleagues are asking questions, we will sit in that chair, in that table. That is why the sort of double arrow is there. Do you see the arrow going backwards and forwards? Everybody nod a little bit so I can see that you're, yeah. But when you are cross-examining, you'll get over there. You'll get off your council table. I don't want you to have to cross-examine from the back of the room just because you got there late that day. All right, so you get up there and you'll cross-examine at that table, and I'll move to the table behind it. There's no real distinction between the various council tables. Then I thought, do I have to worry about everybody taking turns to sit in the best seats? Or do I have to worry about people having a race to get the best seat? And I'm thinking, if you get a close-in table to do your cross-examining, it shouldn't really matter where the heck you're going to sit. But I really don't want to get involved with, I could create a master spreadsheet that for every 2 hours, people sit in different places. I don't want to bother with that. But no, Ms. Mercado, you're not going to hog the best tables every day just because you're the most alert and get there first. Okay, so just try to be polite with each other. Okay, this is not like the French or the Italians. 1989, my wife and I are trying to get to a concert. We didn't know we had to bruise our way in to get the decent seats. Okay, any comments about where people are going to sit? All right, Ms. Mercado, 6 to 10. Tell me about it.
So I think we can accommodate we will need 6 spots and 6 tables. We have several councils, probably a paralegal who will be assisting us. We do have many exhibits, a lot of 20 witnesses plus a rebuttal. So we do have the bigger case to present and defend. And I think that's where we're landing. The council, a paralegal, and at least 2 company representatives that will not be panel witnesses. So I think between 6 and 7 is a number. So I think if you allocate tables for the different parties, at least for the proponents, we can have our our materials there and not having every day to come back and set up
Yeah.
a new every day. I think that would be the best. Particularly because although we're trying to do this remote, we would need to have papers there. So it would be best to have a table.
You didn't mean to say 6 tables, did you?
One
Did you say
table, between 6 and 7. I guess you ask about spots and chairs. I don't
Spots,
know.
yeah. Okay, all right. You don't need to say it again.
Between 6 and 7, yeah.
All right, you didn't mean 6 tables.
No, one table.
No, okay, all right.
We
Right.
might need 6 tables for the interveners. I'm saying it's 3 parties plus the
Right,
interveners.
you don't have to go
We
over it
need
again.
6 tables.
I got it. Well, we're gonna see what we can do, okay? I'm not making any promises because I can't change the size of the room. But yes,
I
you do
know
want,
you're doing your best, Mr. Hampton, but I do think this is important for due process of the parties to have accommodations to better prepare and address
all
the
right,
hearing.
Ms. Mercado, you don't have to elaborate, but I'll tell you what, you find me a case under the due process clause that tells me I have some obligation for a number of seats, and I'll be glad to read it. Okay, we're gonna do the best we can.
Mr. Hampton, I'm saying it's part and parcel of a fair and adequate procedure. I'm not saying that there's a case that would rule on this.
Yeah, I know this. And if it'd be a lot fairer if I had 3 other people working with me too. Ms. Mercado, we're going to do the best we can. We can't change the size of the room. And if I've got everybody asking me for 6 seats, I don't have room anymore. So I know you plead a special case. We're going to do what we can. And when you find that you have a real legal argument in terms of the due process clause or statutory administrative law, you let me know. But in the meantime, go call up Secretary Seda. You're welcome to go pay a visit to the room and have your own ideas about how this is going to work. Okay, so join me in your in this effort. Ms. Mercado-White, I got to move on.
I would say I've been in the hearing room many times, and this is where I'm coming from. We had a prior hearing, which is very tight, and it was there were not many interveners or counsel, so it was very difficult to manage that hearing. So I do have experience.
All right, well, we all are going to have our difficulties. Okay, what I know about the transcripts, I actually don't know this with certainty, but what I've been told is that there will be an official transcriber, that the transcripts will be available 5 days later. I have not found out whether, I have not found out, because I'm not the person dealing with this, whether everybody has to buy their own or whether there's going to be a single copy that everybody gets to make a copy of. I just don't know the answer to that, and I'm waiting to find out. And when I know that, I will let everybody know. Does somebody have experience from other? Well, it doesn't matter. I'll find out when I find out. Okay? Daily plan you can see there. Saturdays. Right now, I want you to plan that the first Saturday we're going to have we're going to need for transmission distribution. I don't expect that we will need Saturdays otherwise, but I need you to plan for that. So we go Wednesday, Thursday, Friday, Saturday if necessary. In general, what I would rather do when we have panels going over is use, an extra hour or 2 in the evening. But I'm a little more optimistic than I think some of my colleagues are about some of these panels and the time estimates. But that's the plan. Cross-examination, just be efficient. And I'm ready for part 6. You all have been very, very patient and helpful today. Thank you. So you see Miss Chambers, go ahead, please. You're muted.
I haven't been to the hearing room, but I don't know if there'll be and it's just a minor issue, but for plugging in laptops, etc., we probably should have some ability to do that if possible.
Yeah, I'll add it. Yep, I would hope so. I'm like you. I'm like. Whoops! Wait a minute. Still there? I'm like you. I need to plug in too. I don't know how that's going to work. And these days, I used to be able to buy an extra battery for my computer. If you're going to travel to Hawaii and you want to work the whole 10 hours, you have a battery in your backpack and you stick it in when the time comes. We don't have those anymore. Everybody wants light computers. They don't think about having a hearing all day. So let's talk about it.
Usually just need some power cords. Yeah.
Well, we need enough plugs too. Okay, Ms. Mercado, yes, please.
Yes, on cross-examination, if it doesn't have to be today, but I was trying to figure out in your assumptions on the hours estimates of Appendix C1, how you factored in. I know you're asking us to be efficient, but I just don't know as you forecasted these times, if you were considering how much time the Bureau would allot for cross-examination. You said 12 hours for T&D between 12 and 24. So what portion of that would be allotted to cross-examination?
Well, it's the whole panel. First of all, these are complete guesses, right? Although I've been doing this for 41 years, so it's a certain amount of educated guess, and I know the record. But if you mean well, there's my questioning and my colleagues' questioning, and then there's your questioning, and the numbers are total for both. Okay. Because they have to come up with 144 or less, or we're in trouble. So that's the entire panel. Go ahead, I'm listening, Ms. Mercado. You think I've underestimated?
No, I'm just thinking, and I can get back to you. In a prior proceeding, at least there were some guidance on the minutes that counsel would get for cross-examination. I know you haven't done this here. I was just wondering if there's a number that the Bureau or yourself are thinking would be, more than 30 minutes would be too much as a general rule, right?
Let me see, I'm not hearing you so well today, but I think what you're saying is, do I anticipate assigning to individuals a particular number of minutes for their cross-examination? Boy, when I was a cross-examiner, I didn't much like doing that. I got in trouble for taking 65 minutes when I was offered only 60. I had some other party complaining. I thought that was pretty good, if 10% over, that's not so bad. No, 15% over. Look, what we're going to do is we're going to ask for people's estimates. Okay, I have that on my list. Isn't that on my list for
videos?
It's on my list for November 1st, November 10th. Receive cross-ex proposed times. So at some point in the next couple of weeks, I'm going to ask you all to send me your proposed times for cross. Okay, and then I'm going to look at that, and we're going to try to find something out. I'm really not comfortable. Well, I understand that if you need to know how you can, how much time you have, so that you know whether to tell me I'm violating your constitutional rights or how to plan your cross. So we're going to start by finding out what people need. Okay. And I'm going to ask you to think about what's important. Go ahead, Ms. Mercado. I don't know that we're going to solve this today or ever. Anything else, Ms. Mercado?
We're trying to lower our hand. We're okay.
Okay. It may just be me, but I've always felt what really becomes the basis for orders is the pre-filed. I mean, I know when I've written orders for states, I've written 3 big orders at FERC, and all I know is I write the whole order based on the pre-filed, and then I go back through the transcript and find out what to add. And what I add from the transcript is usually very small compared to what I had in the pre-filed, because most people who write pre-filed testimony don't go out of their way to have themselves undermined on cross-examination. So don't overestimate the value of cross. I know it's what we all like to do as lawyers. Ms. Chambers, I don't know I can say anything else that's useful on this topic. Go ahead.
No, it's not about that topic, so I'll wait till you're done. Sorry.
All right, I'm done. Go ahead.
Okay. So on the efficiency of the hearing, I just was wondering if there are witnesses that people think they won't cross-examine. I guess we'll find out when we get the estimates, but it would be nice if we could find out sooner rather than later, if we don't have to bring witnesses.
Yeah.
But I don't want to prevent the Energy Bureau from asking questions. So if you have somebody that no one else wants to cross and you have questions, that's fine. I'm just trying to make it more efficient. And for the
it's on the schedule. It's on the schedule. Yeah. It says right here on the November 1st to 10th, it says info from Mr. Brady. The sooner I get that, the better. All right. So you might want to take a shot at that now. And as you said, the fact that you don't want to question somebody doesn't mean that we won't. want to, but
Right.
yeah, we don't want people traveling. Went all the way down to Richmond, Virginia to read my rebuttal and nobody had any questions. So that was that. Okay, what's left? How do you feel about proposed orders? We don't have to decide this today, but what are your thoughts? And my thought is this. If I have you write proposed orders, there's more that I can copy and less that I have to write. And you'll spend a lot less time arguing and a lot more time reasoning. And I'll have shorter documents and more useful documents. And that's my thought. And I don't think you'll lose anything by doing that, but I wonder what people think. Any comments for today? I'm not hearing any right now. Okay, I know nobody's given up their rights, but think about it. And at some point I might say, this is what I'm going to do unless somebody objects. Okay, I have a section here that I wrote in substitute witnesses. So we have one outstanding one that we have to file. Is that right, Ms. Valle? Am I correct that you still have one to file, a substitution
Yes,
document?
that's correct.
Okay.
Yes.
All right. Well, you don't have to do a whole, I mean, frankly, what I thought is you all would file a one-pager that says, I hereby adopt so-and-so's testimony rather than filing a whole nother piece with the redlining and everything else. As far as I'm concerned, for the one that you haven't filed yet, one page saying you're going to be Mr. or Ms. So-and-so is fine with me. That's all we need. Okay. Yes. So the last topic on the agenda is the description that I gave you in Appendix E of how I see our handling this matter in January, February, and March, and I gave you the reasons. I know you haven't had a lot of time to think about it, but I would like to set a date by which, if there are any legal objections, I hear about them. Because right now, I feel that this is the logical way to proceed. So I know people are busy. Can I set a deadline for a week from tomorrow? You don't have to make a lot of comments. What I want to know is if you have some legal objection, because I checked this out with our internal lawyers, and we think that we're okay with this. And I want to know that what I've written here is clear, okay? That what comes out in January on the rev requirement and what comes out maybe toward the end of February on the rate design will be in the form of a hearing examiner order. It won't trigger anything. And yes, in theory, the commissioners could still change their mind about any one of those numbers. But the point is to be in a position where on the 240th day, there is no appellate risk because there's something other than an order with the exact rates that will go into effect. So I'd like to know by next Friday any legal objections, and I'm happy to hear any comments now about trying to solve this equation. Mr. Brady, please.
I just had one practical question about it, which is currently the second round of post-hearing briefs are due February 2nd. So this would come out after February 2nd, I assume.
Well, you make a good point, Mr. Brady. That's pretty alert, huh? I guess you don't want to see a Energy Bureau coming out with its answer before it's seen your reply briefs?
That's what I was thinking, that all the briefing would be in before the decisions are made.
Well, we would like both to say that, wouldn't we? All right, so I have to think about this for a second. I see your point, yeah. By the way, you're okay with the briefing schedule? I'd forgotten that I had set a briefing schedule. That was kind of nervy. So the final reply briefs are February 2nd?
Okay. Yes, initial January 16th, and then replied February 2nd.
All right, I hear you. Well, I'm thinking out loud for a second, Mr. Brady. Tell me if this offends you. I'm going to think about whether, I can delay the first step from January 30th to February 15th. That's possible. You know, that would be the easiest way to do this, is keep everything that I have here the same, but the date on which roughly I would announce the rev requirement decision would be around February 15th to give time to study. The other way to do it is to do it twice. All right, I need to give your point some thought. Thank you so much for that. 1 second. I'm impressed you keep all this in your head. Okay, that's all I have, colleagues. Anything else? Anything else for today? I know we have a very, very busy period of time. A couple of reminders. Let me share the screen for a second, just so we're all on the same page about what's coming next. Okay, I can't see anybody now, but Mr. Brady, can you see this document called Hearing Examiner Actions?
Yes, I can.
Okay, so I sent this around, I don't know, a week or two ago. This is how I keep track of everything you're telling me I have to do. Now, we're doing okay over here, except I gave you guys a little bit extra time on the solar business. So what's going to happen in the next 2 weeks? I'm going to work on defining the panels and getting your comments on that, and then issuing an actual order on it. We discussed today the job of, well, no, we haven't done this yet. Yeah, so I'm going to need, I'll have to put this in an order, but I'm going to need from you a list of issues that you think are, well, yes, you're going to have to look at your planning and tell me where you really think you're going to have to cross-examine and discuss confidential issues. That's what this second, Mr. Bray, I'm just going to use you. I can't see anybody else at the moment. I can't see anybody at the moment. I'm going to be, right, you have a deadline coming up, a couple of deadlines coming up, informing me of any objections, and then I'm going to admit everything that hasn't been objected to, and I really hope not to see any objections. When I get Ms. Valle's final document, which I want to get very soon, I'm just going to grant those motions with a 1-sentence order. I have to have our consultants identify all of their ROIs and the answers that they're going to want admitted as exhibits. I have to give you a chance to object to those, and then I have to issue an order admitting all those. And that, friends, is what has to happen in the next 2 weeks. Does anybody think of anything I've left out in terms of what I have to do? Ms. Mercado? Sorry?
No, I just wanted to flag that I have a comment on, sorry to go back on panels before we finish. Your question on panels.
All right, I'm listening.
Yeah, there's a panel member by the ICPO, Engineer Cosme, who we know from prior proceedings. He's been slated for several panels, including generation and transmission costs. He has not pre-filed testimony, and we don't have any indication of any determination on what he will contribute to these panels. I wanted to raise that and ask that he either pre-file testimony or at least give the parties some information on what he would contribute. I am aware of the ruling that the Energy Bureau will want to ask questions, but there's no indication what the plan is for Mr. Cosme, who I think is in another panel, but at least generation, transmission, and distribution costs.
All right, 1 second, please. Thank you. So the witness who did file testimony, Mr. Vasquez, I can see you now. Yes, how are you today, sir?
How are you doing, sir? I'm doing fine.
The witness who did file is CPA Jaime Sanabria, correct?
Right. Yes. And okay. Regarding the testimony, if present the ruling of the hearing examiner, we're still in an ongoing process if Mr. Cosme will file any rebuttal or not. So basically, that will be, I know that will be part of if it will be into a panel or not.
Okay, let me see if I understand what you said, because I think Ms. Mercado has made a very important point. I'd be worried about his being on this panel if he hasn't filed any testimony,
Right.
because what he would be doing. Well, if what you're saying is he's only going to be on a panel if he files rebuttal testimony, then we're done with this part of the conversation. Is that correct?
That is.
Okay. All right, Ms.
Yes.
Mercado, you okay?
Yes.
Okay. Thank you
Yes.
for bringing that. Thank you again for bringing that up. So let me make a note so that we. Okay. Anything else anybody wants to discuss today? All right. I'm very appreciative of this. I can't imagine what it's like being in your shoes any more than you can imagine what it's like being in my shoes. Mr. Fernandez, go ahead, sir.
Yeah, on
All
your rolling list of issues, the direction as to the implementation of the how do we handle the testimony that we're currently discussing, the excluded testimony, whether it's a red line or strikeout or whatever.
Okay, you want me to add that to my list? Is that what you're saying, sir?
Oh, we need to know how to implement it.
Yeah. That. Thank you. I think I've got that on my notes. Wait a second. Yeah, I got it right here. Solar markups. We'll get back to you on that, Mr. Fernandez. Okay, sir?
Okay. Thank you.
Thank you. Anything else, colleagues? Okay.
On the
Sir?
sorry, one last thing. On the exhibit objections and uploading process, I saw in Appendix A, the deadline for uploading to Axion was extended to the 22nd. When we last checked, Luma's materials had not yet been uploaded, although that may have changed in the last day or two. But I assume the deadline for any objections would also be extended.
Okay, 1 second. Objections to what?
Objections to exhibits before they're admitted. This is per the upload and admission process.
Right.
So we uploaded ours by the 12th,
right.
which I think was the old deadline, and now it's the 22nd, if I'm looking at Appendix A correctly.
I got it. Okay. How much time you want? You want me to extend the deadline for objections, right? Okay.
Yeah, just to have a reasonable interval to be able to look at those materials.
All right. Well, what do you want to say? What day of the week is that? What do you recommend, Mr. Brady? 3 days?
I was trying to look at the calendar. I think it was a week before, but I'm not 100% sure about that. Yeah, 3 business days would probably be enough.
You want me to add 3 business days to the current?
Yes, from
right?
the 22nd.
All right, let me look into that and I'll get back to you with an order, okay?
Okay, thank you.
Okay, anything else? I should have just hit leave before anybody else said anything. Anything else? Okay, I just want to tell folks, I know this isn't easy, and the commissioners and I and the consultants said this before, are very, very appreciative of everybody's work. And I couldn't be more pleased with the professionalism and with the efficiency and with the cooperation that everybody's extended to each other. And I'll do my best to replicate that, and I'll do my best to keep us on track. And I thank you very much, and we'll be in touch. Have a good day. We're adjourned.